All right. Hi, everyone. Welcome back. Welcome back. The attendance is open, so please sign in. I'd like to introduce you to Heather. Heather will be your Langell for comma. She got an A in my class last year. She did a fantastic job with the students last semester, and she volunteered again. When is your first session?
Our first session is a week from Friday, February 2nd.
Okay.
And this published time is 2 o'clock to 3:30. But I teach at Langell from 12 to 1:30 also. And so I'm hoping to start a little earlier. And so if you need to bring food or whatever, you can. And if you need to bring kids, you can, whatever. I have 4 kids myself. So yeah, February 2nd, 1:35-ish. So if you go to Langell earlier, you come straight into ours. So I did it last semester, and I really enjoyed it. So if you have any questions, I will put my email here.
Okay. And I encourage you all to go. One of the things that Heather will work on you with is how to structure your exam answers. I will talk more about the exam probably maybe next week before your first Langell. But Heather will go over old exams with you and give you a sense of how to structure your answer. You'll learn in law school that often knowing how to answer the question is more important than actually knowing what the answer is. You can have the exact right answer and not frame it the right way and actually do worse than someone who learns how to do this. This is for the bar, for anything else. Getting your answer in the right shape is very important. So please email Heather, and I hope you can attend her session. Anything else? Any questions for Heather?
Yes.
Is it in this room?
No, it's going to be in, like, I don't know the room number, 4 or 5. The schedule's, the official schedule isn't out yet. I saw the temporary one. I think it's in 4 or 5. 4:13, 5:30, I don't know. This is 4:13. I don't know.
Okay. Anything else, Heather?
No, I can send, do you want me to let you know, and you can send an email out when we have the specific room number?
I can do that for you.
Okay. Perfect.
Thank you.
Thank you.
Thank you so much. Okay, so the attendance, I'm turning it off now. The way it's going to work is we should keep up for about a minute. I'll give you another 1 minute. This is to make sure people are on time. So if you don't sign in right away, you're going to be marked absent. If you come in late, you're absent. This makes sure people come in on time. This is a 10:40 class. It's not a 9 a.m. class, so you don't have traffic to blame. All right? One note, we do not have class on Thursday. We'll not be here. The class will be on Saturday at noon in room 514. Okay? If you can't come, what I want you to do is email me. Just let me know in advance. That's fine. And then I'll put the recording online. You can either watch it live at noon, or you can watch it on demand. If you email me, I'll certify you excused, so you're fine. So if you have weekend conflicts, I understand people have families and other things. But the class will be here if you can come. I do hope you can make it. All right. Before I even get started, last week we did Marbury versus Madison. And I referenced that at a recent oral argument, a couple of the justices seemed to laugh at Marbury. And you may not believe me. So this is the oral argument from a case called Dalmazzi versus United States. The facts are actually largely irrelevant. They're not important for you. But in 2 instances, Justice Kennedy and Justice Kagan basically chuckled at whether Marbury was even correctly decided. So here's a question where Justice Kennedy asked a lawyer, do you think Marbury's even right? Just listen to it for a minute.
Do you think Marbury versus Madison is right?
A little laughter.
Particularly as to the interpretation with such exception.
Okay. And the second one is Justice Kagan. And the setup here is whether Marbury actually has any relevance, right? And if you look at her question, just focus on her question for a minute, you can see it up here. Justice Kagan is basically saying, is Marbury an actual correct interpretation of Article 3 of the Constitution? Right? Is it? I'll end this now. Okay. You're late, sir. Okay. All right. So just listen to Kagan's question here, right? Where is it? Okay.
Not pointing to anything in Article 3, is that correct? You're pointing instead to Marbury and saying that the principle derives from there. But I could look at Marbury and say, you know, what Chief Justice Marshall was talking about was James Madison handing around commissions, nothing to do with criminal prosecutions.
In other words, they're basically joking that Marbury was basically about the facts of that case, that Chief Justice Marshall was doing, that it was not a correct interpretation of the Constitution. So when I came here in the first day of class, I said Marshall is very much overrated. Let you know that I am not alone in that. Okay. Any questions then from last class? Now they got that out of the way. Questions from last class? Nothing? Nothing in your minds? Okay. What I'd like to do next is work through a series of questions, and I want to explain to the people behind these questions. Very often in common law in particular, issues can go either way. There's not always a clear-cut answer. And in fact, in the final exam, which is all essay, I don't have a clear answer in mind. Every question's written, it could probably go either way. What matters is how you explain it, how you argue one way or the other, because invariably, God willing, you will all be lawyers in a few years, and you will have to defend whatever position walks in your door. And maybe your client has this position, and maybe he has the opposite position. But you need to know the arguments on both sides. So what I want to do with this question is walk you through the exact same question at different points in time. And what these questions are designed to teach you is how the Supreme Court at various points in American history have looked at the exact same question in different fashion. And what I want to teach you is that there is not one correct answer to this question. That is, depending what year you're in, the answer is very different. Okay? Everyone understand why I'm doing this, right? This is not trying to drill you saying that just a single right answer. I want you to understand the progression of how constitutional law has developed. So the question is this. It's actually a fairly straightforward question, right? Congress enacts a law to regulate the wages of workers at coal mine that ship coal across state lines. Congress finds that the moral conditions in mines are low and that safety conditions are poor. Is this statute constitutional? And A is yes, and then B is no. So I'm going to ask you this exact same question in 7 different junctions. Okay, 7 different time frames. Now, these time frames are not random. They correspond to the years of cases that we've discussed. Okay? They correspond to years of cases that we've discussed. The first one I want you to hold for now is in the year 1842. I'll give you about a minute for the first one. The other ones will go a little bit quicker. This exercise will probably take a bit, but I promise you'll be worthwhile. And the other thing about Heather, she's an excellent baker. She brought me cookies, which I'm very happy about, which I will partake in now. There's not enough for everyone last, I'm sorry. I worked with all cookies last week, but she's an excellent baker. She brings her Langdale students baked goods occasionally, if you're lucky, so she's remarkable. Okay, another 20 seconds. Stop it now. Okay. All right. Who was last week? Who was the last person to speak? Okay, Scott, did I call on you? You next. Okay, so Kendall? Okay, what'd you put here, Kendall? True? Yes or no? Okay, explain why, please. Well, you have a 50-50 chance, but did you find your notes since?
No, I haven't. I'm looking for the case exactly because I don't believe that I was the year next.
Okay, so this is a good lesson, right?
Yes.
You need to include years when you put your notes. You need to include years. And the reason why is because this is how my exam is going to be structured. The exam will say the year is 1842, right? And boom, that means you can't cite cases after 1842. All right? Okay, so Raveen, what did you put for this one? Karen, I'll come back to you in a minute, okay? What did you put for this one, Raveen? And why, if that's better. What did you put in why?
I put yes.
Okay, now the why. Well, Raveen, let's walk through this, okay? When I ask you, is this statute constitutional? What should you give me a response beyond a yes or no? What would tell you whether this is constitutional? What piece of information am I actually asking you about? Yes. I'm asking about a case, right? I'm not asking you, do you think this is a good law, right? Does this make sense? Is this policy? I'm asking you case. So.
The case of Madison versus Pennsylvania.
Yes, ma'am, exactly right. So 1842 was the year Prigg versus Pennsylvania was decided. So going forward, right, when I ask you, is this thing lawful, constitutional, whatever, give me a case. I love cases. You'll have in this class, that's 70 or 80 cases. I lose track, but that's 70 or 80. You need to know them all by name. I don't expect you to know the year by heart, but ballpark, like what decade, plus or minus 10, 20 years. You have your notes, it's open book, but you need to know. Okay, good. So, Malia, what was Prigg about? Good review from last week.
Prigg's was the initial fugitive slave act.
Exactly, okay. And what was the issue in Prigg?
Whether Priggs could go and capture from Pennsylvania and bring them back to...
That's right. And what prevented Prigg from returning the slave from Pennsylvania, from Maryland to Pennsylvania? Or Pennsylvania to Maryland, I think.
What prevented him?
Yeah, what got in the way of him doing that?
Oh, the Pennsylvania...
Yes. So was that Pennsylvania law valid?
No.
Why not?
Because it went against the Article 4.
You were really close. What did the Pennsylvania statute violate? You're really close.
It violated...
You said it earlier, a few minutes ago. Not the Constitution.
Or the future.
Yes, that's right. Prigg was about whether this Pennsylvania law violated the Fugitive Slave Act, which was enacted pursuant to the Constitution, the Fugitive Slave Clause. You jumped ahead to the next sentence, right? But the conflict was, did the Pennsylvania law violate or conflict with the Fugitive Slave Clause? Cameron?
I just go when for like the years 1842. Do we treat that as
December 31st. Yeah, make yourself easier. December 31st. Yeah, thank you. So, Stephen, how do we know, Stephen? Well, let me ask you a question before. What happens if there's a state law that conflicts with the federal law?
the federal law?
I'm sorry?
The federal law
The federal law what?
is superior to it.
Superior. Good. And how do we know that?
The supremacy clause.
Exactly, the supremacy clause, right? So when you have a state law that conflicts with the federal law under the supremacy clause, the state law yields, goes away. The federal law trumps. But, I don't see a name tag.
Ambrose, sir,
Okay, please bring it next time. Ambrose. How do we know then if the federal law is constitutional? In other words, how do we know if the Fugitive Slave Act is constitutional?
challenged and upheld by the court.
And well, that's what Prigg was about. What did Prigg hold?
They held that it was constitutional because they broad reading of the necessary law.
That's what I'm looking for, right? So the court upheld the Fugitive Slave Act with a, as Ambrose said, a broad reading of the Fugitive Slave Clause, right? I'm sorry, the Necessary and Proper Clause. They upheld the Fugitive Slave Act as a broad reading of necessary and proper. Okay, and what does that mean, Judge? A broad reading of necessary and proper. Like, what does that mean? I mean, he's Ambrose right, but tell me, what does that mean? A broad reading?
Basically, gives the federal government more power
To do what?
to enact things that allow them to base more decision off their enumerated powers.
Yes. So we have here necessary and proper clause. So it'll be up on this board for the foreseeable future, right? Congress shall have the power to make all laws which shall be necessary and proper for carrying to execution the foregoing powers. Again, Herberto, what are the foregoing powers referred to there? And it says foregoing powers right there in the necessary and proper clause. What are they referring to?
Anything they have to do to accomplish these goals.
Okay, right. And where are those things found? I mean, a little bit more specific.
The Constitution.
Good. Nice guess, a little bit more specific. I think we covered this last week. What are those foregoing powers?
Powers to regulate commerce.
What's that body of things called? You're on the right track. You're very close.
I forgot.
Kelly? Enumerated powers. Yes, ma'am. And where do we find those? Where are those listed? Yes. Kelly's right. Article 1, Section 8. It lists, 17, 18, I always forget the number, 17 or 18 clauses, various things Congress can do. Those foregoing powers, right, to regulate commerce, this gives Congress additional powers, right? A bank is not commerce, but to charter a bank is a necessary and proper way to regulate commerce. It's a necessary and proper way to tax, a necessary and proper way to coin money, etc. But Prig was a little bit of a different case because the Fugitive Slave Clause wasn't in Article 1, Section 8. It came later in the Constitution. But Justice Story said, it's okay, we're going to read necessary and proper very broadly, right? Giving Congress a lot of latitude. That if they want to accomplish a goal, they can probably do it. Okay? So, Alana, let's go back to our question asked at the outset of this class, right? Right? We're in 1842. Congress enacts a law to regulate wages of workers at coal mines that ship coals across state lines. So, Alana, let's be precise here. What exactly is Congress regulating? Just walk me through this. I know it sounds simple, but what are they regulating here?
Regulating interstate commerce.
No. One step down. What precisely is Congress regulating here? It says wages, right? What's a wage? Salary. Is Congress regulating the shipment of the coal across state lines? Is Congress regulating how the coal is mined? Is Congress regulating the prices of coal in the marketplace? What are they regulating? Ah, okay. Everyone, just focus on that for a minute. They're not regulating the shipment. It's not a trick question, but this is the sort of thing I can ask you. They're regulating the wages. I say it in the very first sentence. So, Elena, your answer wasn't wrong. It was a little bit early, right? They think they're regulating interstate commerce. Now, Bianca, let me ask you this question, please. Is a salary paid to a coal miner, say in West Virginia, whatever, right? Actually, West Virginia didn't exist in 1840, so I'll pick a different state, Pennsylvania. West Virginia came into existence during the Civil War, where basically part of Virginia basically broke off. That we don't want to be Confederate. So it's a dubious state. It's unclear if it's actually constitutional. It's debate. Because you can't form a state from another state without that state's consent. So West Virginia is 49 states, I don't know, 50, whatever. Bianca, is the actual payment of wages interstate commerce? I'm sorry, what did you say?
No.
Okay, tell me why not.
Because wages are solely, within the state. It doesn't.
Okay. Okay, and her answer is exactly correct. Her answer is exactly correct. the mere payment of wages, I don't know if there were direct deposit back then, but giving someone money, right, or a check or some sort of local task. I mean, more likely than not, they just gave them some coins, whatever it happened to be. But that doesn't end the question, right? What you need to keep in mind with this chapter is it's not only about the Commerce Clause. It's always commerce and necessary and proper. You need to give me both of them. You need to give me both of them. So, Min, how would the necessary and proper clause play into this fact pattern?
So the Congress would make laws necessary to the wages started. I mean, they start with the wages and to regulate, like they start at the beginning to stop whatever the
Okay. Okay, I mean, I think you're actually on the exactly right track. Let me try this a different way. Why might Congress, if Congress is concerned about coal on the interstate market, right? Why might they want to regulate local wages? Why? Just give me a reason.
to control the supplies.
Also control the supply. So if Congress raises the wages of how much coal miners make, what's that do to the supply of coal in the marketplace? Sorry?
It would make the supply less.
Decreases the supply, exactly. Everyone heard what she said. She made a very good point. If Congress thinks, oh my God, we have too much coal on the market, right? We have too much coal, we need to reduce the amount of coal in the marketplace, right? The prices are plummeting and we need to protect our coal workers, right? Let's jack up the wages. Because if you increase wages, you increase the price of coal. And that will even out the supply, right? Now, is that Ruben?
Yes.
Ruben. Again, Bianca's right. The wages themselves are not interstate commerce. But can Congress regulate the wages in order to keep the supply low and keep the prices high? Can they do that?
Yeah, I think they can also regulate interstate.
No, you're fighting it. Don't talk about commerce. If Congress's goal is to keep supply low and keep prices high, can they do that by jacking up wages?
Yeah.
Under what clause? What clause? Yes, sir. And that is what Justice Story's opinion in Prigg says, that we need to read necessary and proper broadly. It gives Congress the discretion, the latitude, to make certain decisions of how best to regulate interstate commerce. So even though, right, even though the wages themselves are local, what the necessary and proper clause allows them to do is reach that local conduct. Okay? So I want this to be very clear in your notes. Congress could not pass this statute under the Commerce Clause standing by itself. It's actually an exercise of its necessary and proper powers. When you read later today, Jones and Laughlin Steel, Wickard, right? Those are necessary and proper clause cases. They're not really Commerce Clause cases. People don't even realize that, but you have to understand the distinction. Okay? So everyone get that, right? So let's see how you guys did. Hopefully most of you didn't guess. You have a 50% chance. Invariably, the results in these are at 70-30. Let's see what happened here. Question number 1. Yeah, it's pretty close to what I expected. Yeah, about 70-30, right? It's usually 2/3, 1/3. No matter what I do, it occurs naturally. I can't avoid it, right? It happens. It's completely natural. The answer is A, right? Right? Under Justice Story's opinion in Prigg, in 1842, you read necessary and proper in a very broad fashion. Very broad fashion. You can reach this conduct. Okay? All right, well, the next one is a little bit easier, I think. Let's try this one. The year is 1869. Go ahead. I'll give you 30 seconds for this one because it's a little bit easier. I'll eat another one of Heather's cookies. Let's stop it here. But the reason why I don't hit the stop button is once I hit the stop button, you can see the results. I don't want you to see the results right away, so I let it run. Okay. Hey, Kenny. Oh, actually, let's go back to Kendall. You're right in the same trajectory. Kendall, what did you put here? Okay. DeWitt. Oh, okay. Tell us about DeWitt.
That was the case about the oil of the petroleum, prohibiting the sale of the petroleum, and they were either punished by fine or in prison if they did. And the case said that it was too narrow. It was too small a consequence, but he considered that a consequence.
Very good. Very good. Thank you, Kendall. Very good. So DeWitt, right, was a case by Chief Justice Chase. And as we discussed last week, Chase did not very much agree with Justice Story and Prigg. They were very much on the other side of the page. Okay? And in DeWitt, Chase said we can't read necessary and proper so broadly. In fact, he didn't even really mention necessary and proper. Instead, he read the Commerce Clause very narrowly. That unless the activity being regulated was the actual shipment of goods, it was beyond Congress's powers. So under this fact pattern, right, what's being regulated here is not the shipment of wages. It's not the shipment of wages, but, I'm sorry, the shipment of coal, but the wages themselves. So I think under this one, I think Kendall's exactly right. Under Chief Justice Chase's opinion, this would not be a constitutional statute. I think the Supreme Court, under Chief Justice Chase's leadership, would have invalidated this. Even though it's the exact same statute 25 years earlier, that would have been upheld. Everyone see this, right? Let's see how you guys did. Hopefully it reverses. Okay, good. I like this. Very good. This is what I like to see. 90%. Very, very good. Okay? The answer is B here, right? Under DeWitt, and also Hepburn v. Griswold, which was the legal tender case, the first one, right? I think that this statute would not be valid. Okay?
Hepburn came in 1870, right?
Hepburn was 1870, yeah. So basically it's 1 year after, but it's the same idea. But Knox v. Lee was 71, I think. So check that. I think Knox v. Lee was 71.
Yeah.
Am I right on that one?
Yeah.
Okay.
Yeah.
Yeah. So basically before Knox, before the court turned over. Good. But yeah, DeWitt is the correct leading case. Okay. Because remember, all those justices died in a fairly short span. So 69, you're still in the sweet spot. Which is, I think, why I used that year. But okay. Okay. Let's do the next one. Move the rest of these a little bit more quickly. Okay. This one, 1890. Go for it, guys. And I guess Kenny, you got a reprieve, but you're on deck. I'll give it 30 seconds. Okay, 5 more seconds. We'll still come out in another few seconds. All right, we'll stop it here. Okay, Kenny, what's your answer here?
Put no,
Okay, how come?
because of the Knight case.
Very good, and I like the way you said it. The answer is no because of case. Yeah.
The Knight case happened in 1895.
1895?
Yeah.
Yeah, I was confused on that.
What I'm going for with these years is a general genre of cases,
Okay.
right? This is not about remember we talked about the progressive era?
Yeah.
Era of cases, right? There are actually some other cases you haven't studied that actually do this more, but the general genre of years.
Okay. Yeah.
Okay? How about this? Does it make you feel better? Better?
Yeah, you're stressing me with your quote doing. All right, fair enough.
Okay. You all right? Okay, good. All right, Kenny, so tell me EC Knight.
The court said that they couldn't regulate the.
Okay, well, what's EC Knight about? Just take me a step back. What are the facts there?
I forget what state, but there was a sugar company that was manufacturing within the state. The court said that it wasn't part of interstate commerce because it was just manufacturing.
Yes, right. So in that case, the court considered sugar. And they said that the manufacturing of sugar comes before the shipment of the sugar. It's like, duh, right? You can't ship something until you make it first. So first you manufacture it, then you ship it. And what the court held is that you can't regulate the manufacture, that that's a matter for local state governance. Now, Andrew, let's talk about necessary and proper there, right? Why couldn't Congress say that in order to keep this inferior sugar off the marketplace, we have to prevent it from being made in the first place? Why isn't that a necessary and proper way of keeping this inferior sugar off the marketplace?
Well, I think because manufacturing happens within the state.
You're giving me commerce. I'm asking necessary and proper.
I think you would have to go between interstates.
Would you?
Like transportation of that.
No. You're giving me commerce. I want you to give me necessary and proper. Why is this regulation not within Congress's necessary and proper powers? Why? Okay, now you're on the right track. Okay? The thinking here, right? This is consistent with Chief Justice Chase. This is not consistent with Justice Story. They read narrowly necessary and proper. Why? Because wages, again, are the regulations for state law, right? It's for the states to decide local matters. And this goes too far. And the argument's this. There has to be some division between what is for the state government to do and what is for the federal government to do. And in E.C. Knight, the court said this is too local. Okay? Okay? All right, let's see how we did here. Okay, very good. Fewer people participating with each subsequent question, but based on the right track. Okay. I know no one's leaving the room, but we'll leave that there. Okay. All right, we're almost done. We're almost done. All right, Sam, you're on tap for number 5. We'll give you another 40 seconds here. Look at 1934.
Let's skip number 4.
Skip.
Oh, I'm sorry. Okay. 1903. Okay? Do this one. I'm sorry, my apologies. Thank you. I promise this exercise is going to be worth it. It's a long one, but it'll make this class a lot easier. All right, and Sam, you're still on deck. Okay, another 5 seconds. Okay. All right, Sam, what's your thinking here?
I said yes, this is, I guess, in reference to the Champion versus Ames case.
Champion versus Ames case. Okay, tell me why.
In that case, they were trying to regulate the shipment of lottery tickets across state lines.
Okay. Now, this was an opinion by Justice Harlan. What was part of the reasoning of why the court could uphold regulations on lottery tickets? What was part of the reasoning there?
They said that they were trying to protect the integrity of the interstate.
From what though? From what?
From lottery tickets.
And what about lottery is significant?
I guess it's not they didn't consider it moral.
Moral.
Just
Bingo. Right? So I put this in the fact pattern quite deliberately, and this is what you have to be on the lookout for, right? I don't put words in there lightly. As I said, they're worried about the morality. These minds are not good places. The wages are too low. People are engaging in vice, whatever else, right? Sin. Okay? So under Champion, I think Sam is right. The lottery ticket case, this would be permissible. Because Congress is trying to keep this immoral coal off the marketplace, right? This coal created from these slave wages, these low wages, and they're trying to keep the channels, right? The roads, the highways, the rivers, free of this. Okay? Everyone with me? So I think the answer here is that even though we're now only, what, 1895, so what, 8 years, right? The answer flips. So I think now this one is constitutional. Oh, this one's closer. Oh, 60-40. So this one, I think this is upheld under Champion v. Ames. You see, the exact same question flips back, forth, depending what year you're in. Everyone with me so far, right? Okay, let's do the next one. 1935. Okay? 1935. And Cindy, you're on deck. Another 15 seconds. All right, Cindy, what's your answer here? Okay, you think it's unconstitutional, okay? Tell me why. Yes, ma'am. Yes, ma'am. Okay, so tell us, what was Schechter Poultry about?
I think Congress was trying to regulate the church.
Good.
And it wasn't even about shipping to
Very good. But, I'm sorry, so Cindy's right. Schechter Poultry was a poultry case involving, chickens, right? And could Congress regulate the wages and the conditions for local sales of chickens? It didn't matter that chickens perhaps came from out of state, because Congress wasn't regulating that. They were regulating the sale and the wages of chickens in Brooklyn. But, is that Anakari?
Yeah.
That doesn't get us home, because that's that Commerce Clause, right? Why can't this statute be saved in 1935 by our good friend, the Necessary and Proper Clause?
Well, the case said that the federal government cannot push the power to free mass to destroy the distinction between commerce among the several states and the internal commerce of the state.
Very good. So it's the same line of reasoning. There's some difference between what's for the feds to do and what the states are to do. Very good, Anakari. Right? This, the court found, is on the other side of the line, that you're regulating purely local matters, which is not a necessary and proper exercise of federal power. Yes, sir. Is that Brian?
Yeah. Weren't the courts more interested in the fact that you're essentially delegating for...
Yes, we'll get there later.
From Congress and they kind of...
You're absolutely right. They were worried that Congress giving their legislative power to the executive. That's true, but we're going to get there a little bit later. That's actually a different clause of the Constitution, right? We've been talking all day about Commerce Clause and Necessary and Proper Clause. What you're asking about is actually what's called the Vesting Clause, the Legislative Vesting Clause, which says, is Article 1, Section 1, very first sentence of the Constitution. All legislative powers herein granted to be vested in Congress. What does that mean? Congress has the legislative powers. The executive cannot exercise legislative powers. When Congress tries to give its legislative powers to the executive branch, it runs afoul of this. That's what's called the non-delegation doctrine. Okay? The non-delegation doctrine. That is, Congress can't delegate its authority to the executive branch. They can't do it. And Schechter Poultry, Brian, you're exactly right, held that Congress can't delegate their legislative powers to set wages and these sorts of things. So, very good point. That was the holding in Schechter Poultry. Jonathan?
I thought it had to do with interstate versus interstate.
There were a lot of things in Schechter Poultry. That was a really big case. There were several different aspects of the opinion. You're not wrong.
Because I would have translated this to be like, yeah, they could, because it was going to be interstate. And it would be necessary proper to control those prices.
The non-delegation doctrine is totally separate from the commerce clause, right? What if Congress passed a statute saying the president can regulate interstate commerce however he sees fit, right? The president can regulate the shipment of coal across state lines however he sees fit. Now, that has no commerce problems, right? Because it's actually the legit shipment of coal across state lines. But that's giving the president legislative powers. I think that was my final exam question either last semester or the semester before, where Congress gave the president basically full discretion for how to regulate something without any guidance. And that runs afoul of this non-delegation principle.
Legal life poultry code.
Yeah. But just, Brian, 2 seconds. If you notice, Congress and the president, you can enact the code basically however you want. There's no guidance. That was a legislative power to pull that. Now, I'm going to burst all of your bubbles in about 30 seconds. This is no longer good law, right? That's the next one on the list. Schechter Poultry was overturned. So what I'm telling you was correct for about a year or two. 1935 to 36 was a really good swing for the Schechter case. Not so much anymore. But you need to know it. Brian.
Before non-delegation, how does that interact with things such as executive orders? Because that's somewhat legislative.
Well, you're right. An executive order by itself is the president exercising his own executive powers, and he suggests, right? Right? So the difficulty is when an executive order attempts to be legislative in nature. That is, when he actually tries to assume a role that's for Congress to assume. That's where the president goes too far. We'll do a case, I think, next week called Youngstown, Sheet and Tube Company versus Sawyer. And in that case, 1952, it might be off in the year by plus or minus, where in 1952, President Truman issued an executive order to seize the steel mills. He wanted to basically nationalize American steel mills because it was a labor strike. And the court held that it's for the Congress to seize property, not for the executive. So the executive order was unconstitutional because it tried to exercise legislative powers. So this doctrine still has some teeth, right? If the president tries to exercise the legislative power, courts will strike it down. Make sense? But very good. Anyway, but you all recited Schechter Poultry very well. It was a very important case, 1935. Didn't last very long, though. Did not last very long, though. Let's see if you guys pulled this one out. Yeah, nailed it. Yeah, 90%. That's what I like to see. Very good. That's correct. B. In 1935, the statute would not be constitutional. Let's do the next one. 1937. This is our magical year. And again, assume December 31st, just to make your lives easier. Always assume New Year's Eve, yeah. Every New Year's Eve, the Chief Justice issues this report in the state of the judiciary, and there's a small group of people who are eagerly awaiting on New Year's Eve every year the Chief's message. Sometimes they're better than others. This year was a little bit lackadaisical, but Chief's a good writer, and I like his stuff. Okay, another 5 seconds. 1937. Whit, you're on deck. All right, Whit, what'd you put?
I put yes.
So you think this same statute, this coal regulation, will be valid in 1937? Please tell me why.
Starting on the case of NLRB Jones Steel Corporation.
Very good. NLRB versus Jones and Laughlin Steel. Okay, tell me about that case.
The justice in the case said that Congress did have the authority to protect interstate commerce from burdens and obstructions, and it's not limited to transactions which can be deemed an essential part of the flow of interstate or foreign.
Now wait a minute. right? We did a case last week, gently. A case called Hammer versus Dagenhart. Think back. What was Hammer about? Do you remember?
So, children.
Child wages. Very good, right? So Congress tried to regulate child labor. Okay? What did the court do with that statute?
They said that it wasn't constitutional.
They struck it down. Okay? Why?
Because that was for the state to decide.
Very good. The court held in Hammer that the regulation of wages was local. And that if a state wanted to regulate child labor, they can do that. Okay? What about necessary and proper? Right? Rachel, do you remember Hammer's discussion of necessary and proper?
I do not have my notes from there.
Okay, please bring your notes from every class. I'll come back to it later. Irma, what was Hammer's discussion of necessary and proper from last week?
The shipment of goods. The child labor.
Yeah, the child labor case, good.
Congress is regulating the shipment of goods made through the child labor. It was yes.
No. First, please speak louder. It's hard to hear you. Second, the court held that the payment of wages was not interstate commerce. That's easy, right? Why was that law regulating child labor not within Congress's necessary and proper powers? Irma.
Not within the
They're necessary and proper powers. Same question I've asked 5 times today. I'm asking the same question just in different years. What am I asking for? Whether you know the right question, what do I mean when I say, is this within Congress's necessary and proper powers? What am I asking you? Congress, louder, I can't hear you.
If Congress has the power to regulate the wages related to its national team.
Okay. What does necessary and proper add to that question? What do I mean when I say, is this within Congress's necessary and proper powers? I've asked this question 5 times. I'm asking it again. Alexandra?
Laws that are necessary and proper for executing the Constitution.
More specific than Constitution. What are they executing? You're exactly on the right track. They're enumerated powers. That's the right answer, right? Right, so I'll come back to you. Actually, Rachel, I'll come back to you now, right? So when I say Congress is exercising their necessary and proper powers, what am I actually asking about? What am I getting at?
They're exercising powers vested in them by the Constitution.
To do what? Not the states. What are they trying to do there? No. Irma, try again.
Foregoing powers.
Thank you. Yes, ma'am. Foregoing powers, right? So with respect to child labor, I'm going to just finish it up. What foregoing power are they executing? What was this entire class about? Commerce, right. Again, if you don't know the answer, just guess commerce. You're probably right. If you're ever in any doubt, just guess commerce, okay? So David, going back to you, in Hammer, why did the court say this was not within Congress's necessary and proper powers?
Because it was like the manufacturer kind of thing that Congress is not supposed to regulate.
Who is?
Congress?
No, who's supposed to regulate manufacturing?
Oh, the states.
Yes, states. Right? This is a function for the states. Okay, it's a function for the states. Do you understand that? Okay? So there was a dissent though in Hammer, and Justice Holmes was like, how, go back to McClung v. Maryland, right? Go back to these Marshall cases, right? Why is this not necessary? Because the Hammer court read necessary and proper narrowly. Now, is there a name tag there? Name tag? Okay, make another one. What's your name?
Robert.
I'm sorry?
Robert.
Robert. What did the court in Jones and Laughlin Steel do to Hammer? They overturned it outright. Why did they overturn Hammer?
Well, there's the national labor Regulations Act of 1935, and whenever we have the Constitution, we have to listen to.
You're right, but why do they overrule Hammer? We'll get to the National Labor Relations Act a bit later.
Instead of finding the correct impact.
I'm sorry?
Instead of finding the correct impact.
Oh, okay, I thought you were asking a question. I want him to answer the question. I appreciate raising hands, but I like the road thing. So we'll get to your question in a minute. Shivani, why did they overturn Hammer versus Dagenhart in Jones and Laughlin seal? Gabriel? Oh, I'm sorry. Your name tag was blocked. Kevin, I'm sorry. Gabriel, you're on next.
Because they said that the Labor Relations Act goes directly to affecting commerce.
No. Why did they overturn Hammer? Let's just stay on that one question. We'll get to the Labor Act in a little bit. They overturned it and said, we're overruling Hammer. Why?
Because wages come within the commerce power of Congress, or the regulation of wages.
What did they say about Hammer? Did they think Hammer was ever correctly decided?
Well, they said that Hammer looks at constitutional power in a narrow sense. So I guess in Jones they're saying that.
No, I don't want to get to Jones yet. Gabriel, what does it mean for the Supreme Court to overturn one of its own decisions? We haven't seen that quite yet. We saw a little bit before, but this is the most explicit, right? Hammer was at that point, what, about 15, 20 years old or so. What does it mean for the court to overturn one of its own precedents? What does that mean?
That they didn't interpret like the powers. So like they didn't, let's say they didn't use the Commerce Clause.
My question's a little bit more bigger. What does it mean when a Supreme Court decision overturns another Supreme Court decision? What's that? Forget Commerce Clause for a minute, right? What does that mean?
That the way it's decided or the way they came to the conclusion is different.
Shiva, I'll come back to you. Shivani, I'm sorry. Sometimes I always see part of name tags, so I apologize if I truncate your name. What does it mean for the Supreme Court to overturn its own decision from 15, 20 years earlier? What does that mean? No, don't look at your book. The answer's not there. I'm asking you. No, I'm asking her. It's your question. It's not a difficult question. What does it mean for the Supreme Court to overturn one's own opinions? What's the significance of that? Giovanni, let me ask you the question like this. Has the Constitution changed? Commerce Clause is the same, right? Necessary and Proper Clause is the same, right? What changed? Taylor?
The way they viewed the Commerce Clause.
Who's they?
Different.
Who's they?
The people that previously.
What do we call them? What do we call those people?
The justice.
The justice. Yes, thank you. Yes, ma'am. The justices, right? So the way the justices viewed the Constitution changed. Why should that happen? The text has been the same for 200-something years. Ooh. That's what I'm asking, Amber. How can it be that these really smart lawyers, people who become judges in the U.S. Supreme Court, can look at the exact same document, can fit in your pocket, and read it in completely different ways? Look, we're topping 1869, 95, 1903, back, forth. What does this mean?
Well, the country's developing all these years, so industries are getting bigger, people are traveling more, there's more movement of goods and people from one state to another state, whereas, you know, in 1869, people were probably staying pretty localized. So this is where we grow up, and we get our food here, and we do everything here. Once they start to move around, that kind of, it might be that commerce needs to regulate, or that Congress needs to regulate things that might have a substantial effect on the movement.
Now, you're giving me excellent explanation of how our society is developed. Does the Constitution change when society changes?
No. So they're just Congress is using the necessary and proper clause in order to meet an ends to a means.
So you're saying the text of the Constitution is fixed, right? That doesn't change.
Correct.
But the necessary and proper clause gives Congress the latitude to adjust to new
situation.
Gabriel, want to add something?
Yeah, like the interpretation of it.
But she's saying the interpretation is not different. It's that the circumstances, what's appropriate, what's necessary, might itself modify. Is that your point, Amber?
Yes.
Yes, sir, Brian.
Going back to Marshall said the Constitution is a living, breathing document.
He didn't quite say that, but he said something close.
My understanding is that's how I interpret it.
His quote was, "The Constitution is meant to endure for the ages." He didn't say living, breathing. That didn't come to the 1970s. He said it never forgets the
My understanding is the Constitution is a living, breathing document, and our understanding of the Constitution has to adapt and change as the time progresses. Just look at the amendments that have been added to the Constitution. That shows that over time, our understanding of what needs to be protected or what needs to be taken away needs to change. Like 20th Amendment, women get the right to vote. The abolition of alcohol. And then
So let me ask you a follow-up. Is the amendment process consistent with the living, breathing Constitution?
Yes.
So have we amended the Commerce Clause?
No, but we've amended other articles in the Constitution, like Article 4, where we got rid of slavery.
So why couldn't, in the 1930s, the people have amended the Constitution to expand Congress's powers the same way they amended it to give women the right to vote?
Well, I don't think that's an issue that they were looking at, and it's really hard to amend the Constitution.
But if they amended it for giving women the franchise and prohibiting alcohol, why couldn't they give Congress more powers? So the idea of a living, breathing Constitution you mentioned, that's generally not viewed as in the context of the amendment process, right? Article 5 of the Constitution says you can amend it. When people say living, breathing, they usually mean judges for updating the Constitution, not the amendment process. But your point's well taken, right? Your point's very well taken. The Constitution hasn't been fixed. It's had 27 amendments, and they've been fairly significant changes, especially the 14th. But the Commerce Clause hasn't. Now, during this period, 1936-37, President Roosevelt considered an amendment, right? His government considered changing the Constitution in order to deal with changed circumstances, give federal government more power. They decided against it. Why, Brian? You know the reason. Why they decided not to amend the Constitution? I'm sorry? You already said it. You said it a minute ago. Why didn't they didn't do it?
I don't know what I just said.
You said it. You gave me the answer. You already told me. What's the problem? Yeah. Okay. See, you know the answer. You don't remember it, right? Yeah, you're right. It's too difficult. So Roosevelt thought, rather than amending the Constitution, which is really hard, you need 2/3 of both houses of Congress and then 3/4 of the states. That's a lot of consensus. He said, "Know what? Know what's easier than amending the Constitution? Who's next? Juliana. What's easier than merely amending the Constitution? What's a lot simpler?" I'm sorry? You're the president, right? You're President Roosevelt's lawyer. And he says, you know what? I'm mad at Schechter Poultry, right? I'm mad at the Supreme Court striking down my laws, right? You say, well, Mr. President, you can amend the Constitution, or you can... How? How? ... How? No, one at a time, please. I have one rule, one person at a time. Juliana is on deck now, right? How can you
Can the president overturn a Supreme Court decision? No. Who can? Right. So how can Roosevelt change the Supreme Court's interpretation of federal power absent an amendment? What can he do? It's in the reading. Not necessary. Oh, you're so close. What did he try to do? What did Roosevelt try to do? You're so close. Ashley?
Didn't he try to enact new laws?
That would? What would the law do?
That would give more power to the federal government.
Yeah, and how do you get Supreme Court to uphold those laws? What did Roosevelt try to do?
He added more justices.
Okay, now, he wanted to add more justices. Did he actually get it through? No. Very good. Let's pause here for a minute, right? President Roosevelt, recognized, these Supreme Court decisions are not going my way, right? Courts ruling against me, striking down the National Recovery Act in the Schechter Poultry case, right? I can pass an amendment, like Brian said, and say, Congress shall have the power to regulate everything in the world, right? Okay, you can make that amendment, call it the Everything Amendment, right? Congress can do whatever damn well pleases. Pass that amendment, and then Supreme Court to step aside. But his advisor said that is going to be too complicated, right? So instead, they said, let's just appoint new justices, right? Let's appoint more justices who are sympathetic to our federal policies. And they'll overturn it. They'll uphold everything, right? A couple of years ago, 2010, there was a case called Citizens United. You've probably heard of it. It involved campaign finance. Now, it was very unpopular. People didn't like it, saying, it gives corporations too much power. Okay. There was a movement to pass an amendment to the Constitution to overturn Citizens United, to actually reverse it. Now, I think that amendment was a very bad idea. Fortunately, it was going nowhere. It would never get the votes. No chance. But far easier than overturning Citizens United would be changing the composition of the Supreme Court. Had President Hillary Clinton replaced Justice Scalia with someone to Justice Scalia's left, Citizens United would probably have been overturned. So look, how do you change the Constitution? Well, you can have an amendment, 2/3 of both houses and 3/4 of Congress, or you can appoint a single Supreme Court justice. 5-4 one way, goes 5-4 the other way. A lot easier, right? What does that say about the Constitution? If it can change with a single switch vote, Scalia to Garland, whoever it happens to be. Right? Now, Roosevelt's court packing scheme didn't succeed. Even members of Congress said, this is insane. We should not be doing this. We should not be expanding the Supreme Court. But eventually, over time, Roosevelt would appoint the majority of the Supreme Court. I think he had seven or eight justices by the end. Maybe even 9. I can't recall the exact number. He appointed basically the entire court. And these are people who are sympathetic to his agenda. So when you get to Jones and Laughlin Steele, the court just says, you know what? Hammer v. Dagenhart was wrong. It was wrongly decided. The dissent was correct. This was never a correct interpretation of the Constitution. So Jones and Laughlin Steele overturned Hammer. Overturned it. And again, living, breathing, whatever, right? They got new members. The people who were in the majority in Hammer were no longer in the majority when it got to Jones and Laughlin Steele. Right? So I'll get a second number. So the question here, when you get to 1937, is yes, this would be upheld. Look at that, 99. Holy cow! I've never had that. 99% correct. You guys, you got it. You understand what's going on. Wow, I don't know the one person I'm going to just, if they're, I actually appreciate one person got it wrong, because if everyone gets it right, I'm doing my job correctly, right? In a jury, though, to convict, you have to get everyone. Yeah. Amber, yes, ma'am. Let's your hand up a minute ago.
Yeah, in the Poultry case, was Justice Hughes, he wasn't the dissent, right? So he changed his own mind.
He did. Oh, he did. Chief Justice Hughes, Charles Evans Hughes, was the Chief Justice. He was a former governor of New York. He was a fascinating guy. He was actually on the Supreme Court. He resigned from the court to run for governor. I think he ran for president also. And he went back to the court as Chief Justice, right? That doesn't happen today. Back then, judges were very often politicians. That's how they got onto the high bench. But Chief Justice Hughes wrote with the Darby and Schechter Poultry. I think the case was 9-0 also against Roosevelt. A couple years later, he was with the majority in Jones and Laughlin Steel. So it's often said that Justice Owen Roberts, the so-called switch in time that saved 9, changed his vote. He wasn't alone. There was a lot of movement on the Supreme Court saying we need to get in line and get with the program. The conventional story, and then I'll mention this to Amber in a minute, the conventional story is that after Roosevelt proposed his court packing scheme, the court suddenly changed, right? There's this one guy, Owen Roberts, no relation to the Chief Justice, who said, aha, I am afraid of Franklin Roosevelt, I'm going to change my vote. Not accurate. Roberts actually changed his vote in that case before the court packing scheme was announced, and the court had been slowly shifting towards the left over years. For example, President Hoover, a Republican, appointed pretty liberal justices to the court. But Amber's exactly right. There was a shift on the court. So when they say that Hammer was wrong, what they really mean is, we weren't there, we don't agree with it, we're going to do something else. Now the decision in Jones and Laughlin Steel opened up very broadly federal power. Right? Because once you can regulate local wages as a necessary and proper way of affecting interstate commerce, right? If you regulate local wages, that has an effect on interstate commerce. There's very little Congress can't do. Right? And I'll go through these cases more in a minute. But once you get to 1937, Congress basically has a green light to do whatever damn well pleases. Right? So long as they can articulate why this regulation has some sort of effect on interstate commerce, that's enough. What the court tried doing in Hammer and E.C. Knight of distinguishing what's national, what's local, that goes out the window. Everything is now basically under the federal umbrella. Until you're reading for next class, which I'm not going to do today. But next week, we'll talk about 1996. Okay? And a case called U.S. v. Lopez from San Antonio, not too far from here, which involves whether Congress can criminalize bringing a gun into a school. Is it within Congress's power to criminalize the mere bringing a gun into a school? Not the sale of the gun, not the interstate transportation of the gun, possession, mere possession of a firearm in a school zone. The preview of the answer is the court said you can't do that. But from 1937 till 1996, we're talking about 60 years, right? 6 decades. That's a long time. That's like the lifespan of most, attorneys in the bar, right? 60 years. The court showed no limits on the Commerce Clause. No limits in the Necessary and Proper Clause until you get to the 1990s. Now, the sneak preview is it didn't go very far, right? There are only a couple of cases where the court struck stuff down, but there's a little bit of a pushback to this doctrine stemming from the Roosevelt era. Okay, so I think you guys did pretty well in the questions. By the last one, 99%. I'm very happy with that. Very good. Start off around 60%. Okay. Questions on this chronology, on this progression. How the exact same fact pattern goes 7 different ways depending what year you're in. Amazing, right?
How much of these cases, how much did they affect the nation at large? I mean, were these just ping-ponging? I know the Supreme Court's going back and forth, but was Congress, when they had a broad view of the Commerce Clause or the Necessary and Proper, were they starting to make more laws to reflect that?
Yeah. So often this question is like a chicken and egg question, right? Which came first? Did Congress passing broad laws lead the Supreme Court to changing their doctrine? Or did the Supreme Court changing their doctrine lead to Congress passing broad laws? I think in most cases Congress is in the driver's seat. That Congress and the President try to do new stuff. And the court is like the caboose they're following on, saying, well, you can do this, you can't do this, right? And I think it has to be that way. When Congress tried to regulate legal tender, it forced the court to consider. When Congress tried to put antitrust laws with a sugar monopoly, right, then the court had to figure that out. When Congress tried to put limits on lottery tickets, the court followed up. When Congress passed the Poultry Code, court's in the behind. So it's usually the people are like chug, 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 and the court is straggling along, coming from behind, trying to figure out what to do. But it's usually the people, not the court, driving the agenda. Chase.
Do you think that FDR's presidency and how he was so much on the federal powers and putting all these federal acts and stuff like that in the past, is that what played the role for such a long period of time without the change?
I think so. Yeah, Roosevelt was a transformational president. He served 4 terms, and he died halfway through his last one, but he was elected to 4 terms in office. He appointed, I think, 7 or 8 justices of the Supreme Court, and he had a monumental effect on the administrative state in general. One other point to Chase's question, the reason why this lasted, 60-something years, is an entire generation of law students were taught that the court in this earlier period, like these 1934, 35 cases, were wrong. And an entire generation of law students were taught, here's what you don't do, right? Don't do Schechter Poultry. Don't do Hammer versus Dagenhart. Don't do E.C. Knight, right? Jones and Laughlin Steel. Those are the cases. And if an entire generation of law students were taught that, and they believe that, then those law students become lawyers, and those law students become judges eventually. And then eventually, if you were a judge, oh my God, I don't want to be like the Hammer Court. They got overturned, right? That's a cultural shift. Until 96, and I'll mention this for Chase in a moment. You had a guy named Lopez who was 18 years old, senior in high school in San Antonio. Edison, anyone go to Edison High School? Anyway, Edison High School, you know? Edison High School in San Antonio, and 18-year-old brought a gun to school. He was brought up on federal charges. Now, his lawyer, I'm sure, was saying, well, he brought the gun to school, whatever, let him plead guilty, right? He didn't plead guilty. He challenged his conviction on the basis of the Commerce Clause. Now, I'm sure his law professor, wasn't me, his law professor taught him, Commerce Clause is dead, right? Congress do whatever it wants. But he said, I'm going to challenge my client's conviction because Congress can't regulate the mere possession of a gun in a school zone. You'll read it next week, you'll see, or Saturday. He won. He got his client off, right? So this part I shift from law professor to lawyer. You got to always think about these arguments, right? Constitutional law is not a fixed, static thing. It's a wave. And at various points in time, different arguments lose traction, and then they gain traction, right? This 60-year period between 37 and 96. If you just said, oh, whatever, common law's fixed, then you were wrong. Your client goes to jail. So this actually legit matters for the lives of your clients. You'll see we'll do the Affordable Care Act case in a few weeks. Everyone laughed at that case when it first started. And it gained traction, and ultimately they didn't quite win, but they made some progress. At any given point in time, smart lawyers, law students like yourselves, can think of things that perhaps people haven't thought of before, and that's how you make your mark. And that's what this class is trying to teach you. This is why I spend, we're at an hour mark, right? We haven't done a single case yet, but we'll get to it, I promise. But the exact same damn question at 7 points in time yields 7 different answers for 7 different reasons. If you can internalize that and understand that, you realize that you can actually shape things in a way that people don't appreciate. This is why, what horn book do you recommend? No horn book will give you this. Erwin Chemerinsky won't give you this, right? He's a nice guy, but he won't give you this. He'll tell you that everything's wrong except for 1937. That's exactly what he'll tell you. There's a lot more to it. Yes, Craig.
Is it fair to say that any Supreme Court decision is up for grabs?
Oh boy. So his question, if you couldn't hear it, his question is any Supreme Court decision up for grabs? So there's this thing called precedent, right? Stare decisis, which means you stand by your decision. Stare, stand, decisis, decision. It's very rare for the court to overturn itself outright. They don't like doing that because then it sends a message of, well, crap, we're just a bunch of people making it up as we go along. Instead, what they'll do is they'll just distinguish it, saying, well, our case is different than this case, it's a different rule. No. Those distinctions are not always very persuasive. Why I like to focus on the Jones and Laughlin seal case is it's outright. They're saying, look, we are overruling Hammer, period, end of sentence, 5-4, right? We're overruling Hammer. It's done. There was no trying to say, well, you know, this is different than that. We're overruling it. The court doesn't do that very often. I can think of, you know, maybe a couple times this classic rule case, but it's very rare. More often than not, they just kind of ignore it and say, well, this is different, let's figure that out in the case. But as a practical matter, your question is I think is fair. There's nothing sacred, right? There's nothing sacred in constitutional law. You have these cases we've discussed. We call the canon and the anti-canon, right? What is this? The canon are all the cases law students should know. Marbury, McClung v. Maryland, Gibbons v. Ogden, Brown v. Board, right? You know, these really big cases that every law student should know. And you have these other cases, the anti-canon. What's that? Those are the cases that you should not be citing in a brief. What are those cases? Fred Scott, Plessy v. Ferguson, this is a separate train case. Laughlin v. New York, this is a case I'll mention later about bake shops, their laws. And certain cases are saying you should never cite these cases. Well, let me tell you something. That canon, anti-canon is not fixed. Cases that are on the canon may go the other way. Cases that are the anti-canon may go the other way. It's just not a fixed list. And as time develops, perceptions change, and people look at these cases differently. I can't tell you in 50 years what cases will be. I don't know. I don't have foresight like that. But if you know the story of how constitutional law has evolved over the last 200 some odd years, you will be informed throughout the rest of your lives of how things will develop. I can't tell you. I've been teaching now this class for 6 years, whatever it's been. Every year is different. Every year it's something else, right? There's always something new bubbling. I can't even predict what's going to be next year. I've stopped trying. All right. Other questions? Yes, sir, Kenny.
You said, Scalia had been replaced by Merrick Garland. That
Could have been.
United would have been overturned.
Could have been. Yeah.
What is the process? Do they just meet up and they write a new opinion saying?
You're funny. Well, let me answer. So if you remember when we did the legal tender case, Knox v. Lee, do you remember there was a little note where they said the justice tried to reconsider Hepburn and just have it re-argued? It probably wouldn't happen like that. That looks very transparent, right? So what would happen is someone files a lawsuit in some state seeking to regulate campaign finance. Or some state passes a new law doing the exact same thing that was overturned in Citizens United. Right? Think about it for a second, right? California, I'll pick an easy one, right? California passes a law saying, we think Citizens United is wrong, we're going to enact the exact same regulation on the state law. The exact same law. That law gets challenged in court. Goes up to the Supreme Court. The Supreme Court says, you know what? We were wrong in Citizens United, we're overturning this. Now, the funny part is what no one challenges it. It's just let California fall to itself, which I consider as a possibility. But these issues have a way of bubbling back up to the top. The justices don't need to say, you know what, we were wrong, we're going to overturn it. No, they'll wait a couple of years for things to come up. But people are patient. Yes, sir. Yes, ma'am, Stephanie.
Can you challenge like if California were to do something like that, could somebody have challenged it even though there was nothing bad happened or there was no issue with it?
Well, no, the issue is it violates free speech rights.
Okay.
The violation of Citizens United, right? Someone would challenge it. There has to be someone. But the fact that California passes a law saying, we know the Supreme Court said X, we think it's wrong, we want to pass it anyway. That's significant. And they're just going to ignore the Supreme Court now, knowing that perhaps the new justices, Hillary Clinton might appoint 2 or 3 justices, could make it a 7-2 decision. 5-4 becomes 7-2 very easily. Count it up. Yes, oh, your name tag.
Clinton.
Clinton, there you are, yeah.
So the Knox v. Lee case, we didn't read that as part of our assignment. That overturned Hepburn, right? And we didn't discuss in class that for the necessary and proper clause, that just expanded it to broad.
Yeah. I did have you read the Knox case. It's actually quite long, and the little summary of that comes before it's even more useful. But the Knox case more or less follows just a story in Craig.
Okay.
It follows a similar line of reasoning.
Thank you.
But the Knox case was basically exactly what Kennedy asked. The court waited for another case to bubble up, and they overturned Hepburn. And again, it was basically a change in the composition of the court. That's all that changed. A couple of new members were added. 4-3 one way became 5-4 the other way. Jonathan?
How likely is it they expand the Supreme Court again in the near future? Like, is that harder to do now than it was then?
Yeah. So the question was, we couldn't hear, is it likely that the Supreme Court expands? Before the election, when it looked likely that it was going to go the other way, there was a prominent professor at Harvard, a guy named Mark Cushman, who proposed expanding the Supreme Court. He says, pack it, right? As revenge for blocking a vote on Merrick Garland, he says, we got to play hardball and just expand the Supreme Court. That idea was widely opposed, but not universally opposed. I fully expect if President Trump gets a couple more picks and if the election changes in 4 or 8 years, or 3 or 7, whatever it is, there will be movements to expand the Supreme Court. I expect that to happen. Now, does the Constitution prohibit it? No. The size has been fixed by Congress. It's gone up and down. It started off at 5 or 6. Started off at 6, then went to 5, then went to 9, then went to 10, then went back to 9. So it's been 9 for 140, 50 years, but there's nothing fixed about that. But the decision to do that is very brazen. The better question is term limits, right? Is there some way to limit a justice's service to not serve for 40 years, right? Neil Gorsuch, I think he's 50 or 51. He could serve for 40 years. That's a long time, right? That's a really long time to be in the Supreme Court. Could you have a mandatory retirement age and various other things? What Roosevelt tried doing was that for every justice over the age of 70, we'll appoint another justice. That was Roosevelt's plan. It didn't go anywhere. But he's like, oh, they're too old. They can't handle all the work. Right?
How would that be constitutional if it's for life under good behavior? I mean, how do they get around that?
All right, so I'll answer your question. There's no strict requirement that all 9 justices hear every case. So you could have a court of, say, 18, and you draw 9 from that 18. Now, that might not be constitutional. Chief Justice Robert, I mentioned earlier that every year the chief issues these end-of-the-year reports every January. Usually they're about budget and boring stuff, but a couple of years ago he had one that was really significant. Congress was considering putting an ethics code on the Supreme Court. Believe it or not, the Supreme Court's not bound by the ethics rules. They're not. Only the lower courts are. And the chief issued this opinion, which was fascinating. He said, well, the Constitution creates the Supreme Court, not Congress. Therefore, Congress can't put rules over us. And he said there's one Supreme Court. One. Which would make the idea of having panels. So I think the Chief Justice suggested you can't have this with 18 judges and you draw 9 at any given point. You have to have one court wherever hears every case. Now that's the Chief Justice in issuing an opinion in his budget message, right? Which was very strange. I didn't like that one. But it was that was not accidental. He made that point very deliberately. But back in 2009, when politics were different, there was a very strong movement afoot to do this senior status, where basically after you hit the age of 75, you only hear a case if there's a recusal, right? So they say the 9 youngest people hear cases, and if there's a recusal, you draw from the senior lot. I don't know if that's valid, but it was proposed. Law professors are dangerous, right? Especially when they have power. And this is a law professor proposal. Never let a law professor have any power. It's a very bad idea. which we kept in our offices and talking to students. What else? Anything else? All right. Let me. Oh yes, sir. Brian, go ahead.
In giving the argument, it can bring up the issue of dormant commerce clause. It can bring up the issue of dormant.
Yeah, I'm not covering that.
But as far as like any other enumerated powers in the Constitution, does that same aspect apply to anything else?
The dormant commerce clause?
Or just enumerated power being dormant, meaning that Congress doesn't necessarily act on it, but it still has the right.
Let me answer this question. I deliberately don't do this when I do Gibbons because there's another topic that gets complicated, but I'll talk about it briefly. Okay, so Congress has the power to regulate interstate commerce, right? So Congress regulates the shipment of boats from state A to state B. That preempts any state law, right? No argument there, right? If Congress regulates interstate shipment between boats from New Jersey and New York, that preempts state laws. Marshall, in his wonderful opinion, suggests that, well, what happens if Congress didn't regulate interstate shipment, but they could, right? What if Congress had never regulated shipping of boats from A to B? Could New York act there? And what Brian is alluding to is something called the dormant commerce. This is not an exam, so you can stop listening now, but I like answering questions. The dormant commerce clause. What does dormant mean? Well, dorm means sleeping, like a dormitory, right? Dormant commerce clause. That even if Congress hasn't exercised their commerce powers, states still can't regulate it, right? So if Congress had never regulated boat shipment, states are still disabled from passing laws in that area. That's the dormant commerce clause. John Marshall made this up. He made it up. It doesn't exist. It's not real. But the Supreme Court has recognized it for 200 years, and so it's an actual doctrine. But there's no evidence this is real. Justice Thomas, who I think is right, says that this is a fiction. It's not real. There is no dormant commerce clause. If Congress hasn't regulated something, they can, but they haven't. States are free to act. So that's the answer to your question. No, I don't think there are other dormant provisions. John Marshall basically made this up. Another reason why I think he's overrated. He made it up. He has this one little paragraph. If you go back and read Gibbons, he mentions it briefly. Very brief. It's like one paragraph. He made it up. Thank you, Brian. This is why I don't teach you, because it doesn't really go anywhere. There's a chapter in your book on dormant commerce clause I'd never assigned it. I think it's not a good use of class time, but it's there. All right, what else? All right, let me walk you through the first 7 or 8 cases. We'll spend time on the New Deal case, but I'm going to walk you through each case briefly. So we talked about the first case, Schechter Poultry. This is often called the sick chicken case. I wish I could make up a nickname that good. I'm not that talented. But it's called the sick chicken case, which involved the effort by the federal government to allow the regulation of local wages. Now, there's a background to this case that most people don't appreciate. But the Schechter brothers, I think I have a picture of them somewhere. Oh, here we go. It's hard to see them here. But the Schechter brothers were Jewish bakers. In fact, the word shecht means to butcher or slaughter in Hebrew. Part of kosher slaughter, that's a Jewish ritual slaughter, is you can't kill sick animals. If a chicken is sick, tuberculosis, whatever it is, you can't slaughter it. So part of the process is you have to check, is this chicken sick? If it's sick, you basically throw it out. The labor codes enacted by Roosevelt's administration said that if you are a butcher, you can't pick and choose which animals you slaughter. It's called straight killing, right? You have to kill everything that comes in front of you. And if you're a customer, you can't pick and choose which chicken you take from the butcher. You have to take whatever they give you. This was not permissible under religious teachings. So they opposed it, and they refused to comply. Now, the case wasn't about free exercise or religious liberty. This didn't have any bearing on the case. But they actually tried the Schechter brothers for a crime of violating these codes, of not allowing people to take whatever chicken's given to them. There were a few different grounds on which the court ruled. The primary ground is that the actual slaughtering of chickens is not interstate commerce, right? It's not interstate commerce. Even though the chickens might come from out of state, Pennsylvania, wherever, the actual act being regulated was local in nature. Okay, it was a local act in nature. This was what the court said was an indirect regulation of commerce. Indirect regulation of commerce. It was not a direct regulation of commerce. Okay? As for the necessary and proper clause, which you always must consider, the court said that this is too far. It goes into the province of what the states ought to regulate and not what the federal government ought to regulate. And the court mentioned, I think Brian brought this up earlier, the non-delegation doctrine. That this statute, this National Industrial Recovery Act, what's called the NRA, by the way, this is not National Rifle Association, this is the National Recovery Act, the NRA. The mascot was a blue eagle, that was the mascot. It's very fascist if you look at it. It is, right? But as part of Roosevelt's New Deal, the government could basically write laws. Congress had pass whatever labor regulations you want, and that's fine. The court said, no, it's for Congress to draft laws, not the executive branch, and this violated the non-delegation doctrine. So this was a 9-0 decision decided, it was in 1935, which was a solid rebuke of the Roosevelt administration. Again, 9-0. It would not last long. This case did not last long at all. So any questions on Schechter Poultry? We covered most of it before, but this is a summary. Yes, sir, Evan.
What was the purpose of the straight killing provision?
To reduce waste.
Okay.
It was to make sure that all the chickens were being eaten, even if they were sick. That's why it's called the sick chicken case. And this was actually a criminal prosecution. They could have gone to jail for this, and this was legitimately a criminal offense because it would shut down their business if they got to jail.
On the test, can we make the reference to nicknames or do you have the action?
You can call this sick chicken case. That's fine. You can call whatever you want. I mean, I'll know what you mean. Yeah, Kobe.
What they got, what Congress been able to do is they said they could regulate the shipment because over 96% of shipment.
Yes. So, under the rule in Schechter Poultry, if there in fact had been a regulation of shipment, that's fine, right? That's Champion v. Ames, right? The lottery case. But they didn't do that. They were trying to regulate the local labor conditions. All right. But again, any other questions on the chicken case? Okay. The next case is very significant. It's NLRB, the National Labor Relations Board versus Jones and Laughlin Steel. This was a company that had basically steel mills across the country. Okay, very significant case. As I think Amber mentioned a few minutes ago, Chief Justice Hughes wrote the opinion, even though he was in the majority in Schechter Poultry a couple of years earlier. And the court upheld the National Labor Relations Act. What was the National Labor Relations Act? It regulated all facets of labor. Wages, union, workplace conditions. It was a very broad delegation of authority to this new agency. This case expressly overruled Hammer versus Dagenhart. It got rid of the direct versus indirect distinction in commerce. Even though this was regulating the wages, not the shipment of goods, the court held it permissible. Now, why? Now, be very careful here. The court never held that payment of wages and labor conditions are interstate commerce. Let me say it again. The court did not hold that the payment of wages and labor conditions are interstate commerce. What they held is that this is permissible under the necessary and proper clause. Why? Right? Because these activities have a substantial effect on interstate commerce. That these local activities have a substantial effect on interstate commerce. And because of the substantial effect, it's swept within the necessary and proper clause. Right? It's within the necessary and proper clause power because of the substantial effect. Okay? That's what you need to know about the Jones and Laughlin Steel case. It's not only about the Commerce Clause. It's Commerce Clause and necessary and proper clause. You need to get both of those in there. Okay? Okay, so the substantial effect test was developed in Jones and Laughlin Steel, but elaborated upon in the next two cases, Darby and Wickard. So any questions on NLRB versus Jones and Laughlin Steel? Okay. Next case is U.S. v. Darby. Okay, again, this is post 1937. This is post that shift in how the court approaches federal power. Okay. This case looks at whether Congress has the power to prohibit shipment in interstate commerce of lumber manufactured by low-wage workers. Okay. This case is actually a little bit easier because it's about the shipment of goods, right? However, the court had said in E.C. Knight that manufacturing comes before commerce. And what the challengers argue here is that, look, this case is not actually about shipment of lumber. They're trying to regulate the manufacturing, right? They're trying to get around E.C. Knight. Manufacturing is separate from shipment. They don't really care you ship it. They're trying to regulate the actual manufacturer. What did the Supreme Court hold? Doesn't matter. Doesn't matter. Right? Again, necessary and proper. They found if Congress determines that the shipment of lumber, right, has a substantial effect on interstate commerce, that the low-wage workers making substandard goods, that this has an effect in interstate commerce, it falls within the necessary and proper powers. This is like E.C. Knight. This is like Champion v. Ames, the lottery case. Congress can prevent inferior goods from going into interstate commerce. So this case basically overturned E.C. Knight. Right? E.C. Knight held that manufacturing is separate from shipment. This case says, no. If Congress wants to regulate the shipment as a way to go after low-wage goods, they can do that. So this case overturns E.C. Knight and reaffirms Champion versus Ames. But everyone sees the difference. This actually involves shipment of goods. What the court said here is it doesn't matter if the real purpose, the motivation of this law, is labor. Right? Congress can go after local labor through their necessary and proper powers because of the substantial effect in interstate commerce. That when Darby ships the substandard goods across state lines, it depresses wages nationwide. That is a problem that Congress can remedy. Yeah.
You're talking about the E.C. Knight. I thought that was Hammer. It overruns Hammer.
Well, also E.C. Knight said that manufacturing is separate than shipment. Remember the manufacturing of sugar?
Yeah.
Right? Okay. E.C. Knight. Hammer had already been overturned by Jones and Laughlin Steel.
But it calls out Hammer in this case.
Oh, it does, yeah.
Okay.
Yeah. Okay. Right. So at this point, Hammer's dead. E.C. Knight is dead. Right? Hammer's dead, and E.C. Knight are dead. What remains? Champion v. Ames. Right? Champion remains. And we are champions, right? Champion remains. Okay? So any other questions on Darby? Jones and Laughlin Steel and Darby decided basically back to back, right? These are fairly close in time. And these were used to dismantle Hammer and E.C. Knight. Questions? Okay, so by the time you get to Darby, Hammer's gone and E.C. Knight is gone. Okay? So any questions on Darby?
The substantial effect test, I mean, I know they applied it to the shipping of wood, but that's just overarching at this point, right? Okay,
yeah,
so
between Jones and Laughlin and Darby decided basically back to back, right?
Yeah.
Between those two cases, it established a substantial effects test.
Okay, so it's just overarching, we're gonna, okay.
Yep.
Thank you.
Yeah, you look a little bit, you good now?
Yeah, I'm good.
Okay, good. All right, thank you. All right, so again, Darby, Jones, and Laughlin were basically back-to-back cases. Those cases get rid of Hammer, right? There's no more direct-indirect test. Those cases get rid of Darby. I'm sorry, E.C. Knight about the manufacturing commerce distinction. Okay? The test that remains now is one of substantial effects. Okay. The next case is very significant, right? This is the case Wickard v. Filburn. This is the case that gave the court the most difficulty. At issue was the regulation of wheat, locally grown wheat, on a single farm. Now, this wheat was not designed to be sent in interstate commerce. It was planted for the sole purpose of local consumption. That is, a farmer would eat it for himself, his family would eat it, his animals would eat it, his livestock would eat it, but it never had any plan to enter the interstate marketplace. Okay? It had no plan to enter the interstate marketplace. Now, Filburn had almost 12 acres of excess wheat, which yielded 239 bushels of extra wheat. Now, I don't know the first thing about farming. Students have told me that's a lot of wheat. You want to tell me 239 bushels, is that a lot of wheat?
A bushel is kind of like this, right?
Yeah. No farmers, Texas? Is that a lot of wheat? Okay. So the story goes that he was probably full of it. He was probably selling this to the black market, but it didn't matter, right? The court, as the notes discussed in the Cushman piece, wanted to resolve this case. They wanted to resolve this to settle once and for all this New Deal program. So how does a court go about arguing that Congress would regulate wheat, which was never going to leave the farm, let alone the state line? This is the application of Jones and Laughlin and Darby, right? Wickard v. Filburn was in 1942. Came a couple years later. Was the application of Jones and Laughlin, Steele, and Darby. Okay, so first off, who's next? I'll call people now. Back to your case. Okay, Sophia. Does the court hold that Mr. Filburn's wheat, this locally grown wheat, is that interstate commerce? No. So on what basis does the court uphold the regulation of that local wheat?
Because in the aggregate, there is a substantial effect.
Very good, very good. Wickard is a necessary and proper case. This is actually Roscoe Filburn, the farmer. I love this picture. He's putting the grains of wheat in his hands. And this is Claude Wickard, who's a Secretary of Agriculture. And I love this picture too. If you look in the background, there are all these graphs and charts on the wall of the price of eggs and the price of wheat and rye. They're trying to have a nationwide plan for the regulation of commodities. They said if we set the right price, we'll have prosperity. These policies were absolute disasters, but that's secondary for our case here. So Sophia said correctly that the court did not hold that the locally grown wheat is interstate commerce. It didn't hold that. Instead, it was a necessary and proper clause. They said that the locally grown wheat has a substantial effect in interstate commerce, right? Laura, why does a locally grown wheat have a substantial effect in interstate commerce?
Because it takes away goods from the market.
Takes, how so?
Because if he's growing his own wheat and consuming it and also having stuff left over, it kind of affects, it has a substantial effect on the wheat market because he's kind of just keeping everything to himself.
Very good, very good. So look at it like this. If I'm a farmer and I can grow my own wheat, my chickens and my cows and everything else, I don't need to buy that on the marketplace. By using my own wheat, I am no longer having to go out and buy more. That increases the supply of wheat on the marketplace, and that depresses wages. So the farmers who follow this rule have lower wages. Congress says we want to keep wages high, so we'll keep supply low. My locally grown wheat screws up Congress's plan, right? They can't manage or supply. I am growing my own wheat. Therefore, the decision to grow locally grown wheat has a substantial effect on interstate commerce, and therefore it falls within the necessary and proper clause. That is, as a necessary and proper way to keep the demand high and keep prices high, we're going to go after local farmers, right? We will regulate locally grown wheat in order to keep the marketplace at the level we want. That is the basis of Justice Jackson's opinion. Now, he doesn't endorse that as a matter of economic policy. Rather, what the court says is it's for Congress to decide what policy they want, and we will uphold it unless we find a really, really screwed up reason why it's bad. So, the bottom line of this case, and this case gives people angst, that Congress has the power to regulate locally grown wheat. Now, when you read the Cushman piece, it gives you the drafts of what Jackson had drafted, right? Which I like that part of the reading. Jackson acknowledged in one of his drafts, once we do this, basically the ballgame's over, right? Once you give Congress the power to regulate locally grown wheat that never crosses the state line ever, there are no limits. There are no limits anymore. That basically Congress can do whatever it gets away with. Whatever it has the votes to do, that's what Congress can do. Jackson did not mention that in his final opinion. I wish he had. He took it out. Maybe one of the judges asked him to do it. But this is the widest extent of the court's power. Wickard. This is basically, once you get to Wickard, there are no more limits. That's it. And that's why from 1936 through 40, whatever, 1936 to 1996, whatever it was, there's no limit. Jones and Laughlin and Darby started it. Wickard finished it. That's it. All right, 60 years, go.
One thing I was wondering while reading this, while you have the New Deal courts who are slowly, case by case, widening the powers, while reading this one is, as you said, the most kind of extreme widening of it. But do they still come to the same agreement if this happened 12 months earlier, before Pearl Harbor? Is there just starting at World War II?
Well, so if you read the Cushman piece, they considered re-arguing this case a second time. Perhaps the ongoing war made them think, I'll just get this over with. We'll do other cases decided during the same period involving Japanese detention, or Matsu, Yobayashi, and Endo, which more directly implicate that. But by this point, Roosevelt had appointed, I think, 6 or 7 justices. They were basically all, I think they were all on the same page. The only question is how they got there. And Justice Jackson was I think, personally torn of how to get there. He had different approaches, but eventually decided to do this one, and that was it. Yes, ma'am. Is that Ashley?
Yes. This isn't necessarily pertinent, but I guess it's just a question that I had. In the book, it says that after this case, Filburn changed his name.
Yeah.
Why is that? Was he changed or?
It could have. This is 1942. It could have had something to do with German, anti-German sentiments, maybe because of Germanic descent with the war. I think that was the correct spelling. He wanted to change it. I'm not exactly sure of the reason. But I appreciate that. Thank you. I'm glad you were very close enough to notice that. Maybe he didn't want to be associated with this case anymore. I don't know. I don't know the answer. Yeah, Jonathan.
How is it accepted by all the farmers, this decision?
Well, let me ask you this question. Do you think farmers liked or didn't like this regime?
I truly don't know. I would be mad if I was that farmer. I figure that's my land, I own it.
Well, so here's the rub, Jonathan. Most farmers like this roll-off because it created artificially high prices. The purpose of this entire regime was to inflate prices. That's why it existed. So farmers like this. Basically what the government did was they paid you not to sell your crops. They paid you not to grow crops. Farmers loved it. Consumers hated it. Consumers never knew, right? Consumers don't know why the price is what it is at the grocery store. They just pay whatever's on the shelf. These guys did. These are the brain trust, right? They figured out the perfect price for wheat. And they said, here's how many acres you can plant. Now, you always have your rabble-rouser, like your Roscoe Filburn said, screw this, in my land, right? But most farmers liked it. In fact, this is mentioned in the book. The way that these acreage limits were set was by referendum. The farmers actually voted on it. And if you remember correctly, 80% of farmers approved of this referendum. So most farmers were happy with it. In fact, the reason why this case arose is because apparently Mr. Wickard lied. He said to the farmers, I'm going to give you these terrific bounties and these terrific loans, and he basically overstated what he actually would give. So he basically lied to the farmers, but that's how this case came to be. All right, questions? All right, let me do the next two cases, or actually the last two cases. So far, all the Commerce Clause cases we've done are pretty boring, right? Regulating wheat, sugar, steel. You guys don't care about that. This is what you care about, right? Civil rights. The 14th Amendment was enacted in 1868. The second half of our class is basically exclusively on the 14th Amendment. We'll get there after the midterm. But I'll give you this much now. Section 1 of the 14th Amendment provides that no state shall deny to any person within its jurisdiction the equal protection of the law. This is the provision that has been used to desegregate schools and other institutions. But for your purposes here, the key word there is state. No state shall deny equal protections. Does it apply to private businesses? The Supreme Court said in a case called the Civil Rights Cases, that was the name, the Civil Rights Cases, that it does not. That the 14th Amendment applies only to government institutions, not to private businesses. So even though you had this 14th Amendment, the Supreme Court said early on that Congress can't use it to desegregate, movie theaters, hotels, restaurants, etc. Places of public accommodation. So from the 1870s until the 1960s, segregation laws were basically the matter of state law. States could do whatever they wanted. That gradually started to change in the 1950s, but Congress intervened in 1964 with what's called the Civil Rights Act of 1964. This was probably one of the most important statutes ever created. I don't say that lightly. People often have this very big view of the courts. Wow, the courts saved the world. No. The civil rights era was driven primarily not by the court, but by Congress and President Johnson, and the enactment of the Civil Rights Act of '64. Title II of this law, the Civil Rights Act, sought to desegregate places of public accommodation. Hotels, restaurants, theaters, salons, whatever place that's publicly open. Okay? The reason why Congress enacted this statute was in part because of the problem identified in this book. Anyone ever see this book before? The Green Book? This was a guide that African Americans used in the 50s and 60s of traveling throughout the United States. That is, if I'm going from point A to point B, where can I stop to get gas? Where can I stop to get dinner? What hotel would actually accept me? These are online. You can flip through them. You can look up Houston if you want. There are few places, far and few between, that would work. You would often have accommodations, cabins, that were restricted based on race. So Congress recognized this problem, and they said it's very difficult that if you're an African American traveling from point A to point B, it's not just the South. Like Delaware, Ohio, it's everywhere. It's not just a Southern thing. If you're traveling from point A to point B, state A to state B, there are things obstructing your movement, namely these segregation laws. So Congress enacted the Civil Rights Acts to open up the channels of transportation. So the cases, Katzenbach v. McClung and the Heart of Atlanta Motel, were extensions of the Commerce Clause doctrine. Again, the Civil Rights Acts were not upheld as violations of equal protection. Rather, they were included with Congress's power to regulate interstate commerce. So the first case, right, by the way, crazy story. Where is it? So this is the Heart of Atlanta Motel. It's currently at Hilton. But he has this humongous swimming pool, right? A few years ago, I showed this picture in class of, see this, there's a boat inside the pool? And the student raised her hand. It's like, that's my aunt. Her aunt was a woman sitting in this boat. And she had seen that picture 100 times and never knew the context. Anyway, so her aunt worked there, or at least was a model for them. So the first case involved a hotel. And the hotel argued, wait a minute, I'm a hotel, I'm local, I am not interstate commerce. But the court held, no, a lot of your clientele are from out of state. You advertise on billboards. You attract business travelers, right? So because a substantial portion of your clientele comes from out of state, interstate commerce. This case is more narrow than Wickard, right? This case is more narrow than Darby. This is legitimately people traveling from out of state. So the Heart of Atlanta Motel case isn't that difficult, right? It didn't represent an expansion of doctrine. The next case did, right? Right, there's a Heart of Atlanta Motel. See the advocate at AAA. Next case called Katzenbach v. McClung. This was a barbecue joint in Birmingham. Ollie's Barbecue. And actually, I have a, I'll show you this. I have, they're out of business now, but I actually got a case of their barbecue sauce. I never tried it, right? But I got a case upstairs. If you ever want to look at it, you can pass it around later. But Ollie said, look, we don't appeal to customers out of state, right? We only appeal to local customers. The court said, but a substantial portion of your food comes from out of state. Therefore, your business substantially affects interstate commerce, and under the Necessary and Proper Clause, Congress can regulate your accommodation. Now, I actually have proof, indeed, that their materials came from out of state. I have an eBay alert for lots of Supreme Court cases. It's true. And I found this matchbook, picture up here, of Ollie's Barbecue from the 1960s. And if you look very carefully, you can see it up here. It says, Universal Match. What does that say? Atlanta, which is in Georgia, which is not in Alabama. So I have proof that indeed they got some of their materials from out of state. So the court said is, again, the fact is that their business, which imports a lot of food, has substantial effect in interstate commerce. Therefore, Congress can reach it under their necessary and proper powers. These cases are easy, the Heart of Atlanta case and Katzenbach, because they are merely extensions of Jones and Laughlin Seal, Darby and Wickard. Those are the biggies, right? These are just mere follow-ups where the court uses the Necessary and Proper Clause to get at civil rights laws. I'll mention briefly in passing their concurring opinions from Justices Goldberg and Douglas. And they say, yeah, Commerce Clause, that's all well and good, but we should base this case on the 14th Amendment. And I'll mention this briefly, we'll come back to this later in the semester. Congress has the power to enforce by appropriate legislation the provisions of this article. A lot of people think that Congress could regulate private businesses under what's called Section 5 of the 14th Amendment, but they don't need the Commerce Clause. This position only garnered 2 votes. It hasn't gone much further, but we'll come back to this position later this semester. Don't back up, I got a minute left. Questions? Yes, sir, Brian.
You're talking about the Civil Rights Act of 1964. Isn't the Civil Rights Act of 64 just a reiteration of the Civil Rights Act of 75 or 1875?
The Civil Rights Act of 1964 did a lot of different things than the one of 75. When you do the civil rights case in about 6 weeks, you'll see why. But they do different things. Anything else? Yeah, Judge.
Yeah.
I got a minute left. Yeah, Judge, go ahead.
The Saturday class, are we meeting in this room?
I think I said, was it 5:14? I said it earlier today. Did I say it? Yeah, I think I did. Yeah, it's room 514 at noon. Okay, thank you all. I'll see you on Saturday. Thank you so much.